I'd like to welcome everyone that's taking part and that will take part in a few more minutes. We had 302 registered, and we have about 75 so far taking part tonight, which is about average. I'm expecting perhaps another 25 up to perhaps 100 of the 300. That's an average kind of turnout. And everyone knows, of course, that you register for things and then life intervenes, or you just decide that you've had enough for the day, that sort of thing. And for that reason, I'm going to try to keep this to be done around 8. I invite everyone to ask questions, post the questions, be glad to see them. My assistant Karen is in the other room. She'll reply to a few of them. She'll reply on the one hand, and she'll bring to our attention ones that she thinks particularly need to be answered, or that, for example, several people have asked similar questions. So, everyone feel free to ask questions. This will be a short version of my annual update. We do webcasts every month. We have different panelists, different themes, but there's always recurring items that need to be touched on again and again, so that people know what they can have, what supports they can get. Liisa, would you care to say a few words about Ausome Ottawa?
I would. Thank you so much, Ken. I wanted to just tell your attendees about Ausome. Ausome is an organization that provides sport and recreation to children with autism and creates community connections for their families. And we've been around it's almost exactly our 4-year anniversary. We have about 300 families who take part. Our programs are all completely free. We do ask for a $25 a year donation per family. And that is basically a way for children to take part and learn all the things that they need to learn to do to play like typical children do. They learn to run, they learn to jump, they learn to throw, they now learn to paddle in the water. In water polo, they learn to paddle. In boats, in dragon boating, they learn to cross-country ski. So we now really cover all the different surfaces that children need to learn to play on, just like typical children. And if you have a child with autism or any other type of challenge, you know that sometimes they need a little bit of extra to learn the skills of play, but they can learn. And that's the philosophy at Ausome, is that all children deserve a chance to play and to learn to play. And so you can find us at Ausome, AUSOME, as you see on your screen, ottawa.com. And any child with autism or with suspected autism can join and become part of our community. And Ausome, you may not know this, even if you've heard of Ausome, is that Ausome is 100% community funded. So we get no government funding. The programs exist because of our donors, our supporters, and people like you guys in our community. So who tell a friend, even if people don't have extra funds, because many people in our community don't, but they will tell other people about Ausome and about the community funded aspect of Ausome. So just so you know, as I mentioned, we have 300 families that participated just this year. We also do training for people in the community who support children with autism in recreation and sport. So we've trained, since we started, we've trained over 650 people. Just this year, I think over 250, I'm looking at my paper, 250 coaches and instructors and educators and caregivers on how to support children with autism in sport and recreation. So that's a really important part of what we do, because we believe that the whole community can become more inclusive if people could just have a little more training and a little more, even sometimes just the thing that makes things change and click is a little bit more awareness. So that is what we do at Ausome, and I'm going to turn it over to Ken. He's going to give you the information that you came here tonight for, and thank you, Ken, for giving me this opportunity.
That's great. That's great, Liisa. Are you familiar with any other groups like Ausome? I'm not.
No.
No?
In Ottawa or in Ontario, no. Across Canada, there are groups that'll do one sport or another. In British Columbia, there is an organization, but they focus specifically on British Columbia.
Yeah.
But otherwise, across Canada, there is no other group like ours.
Yeah, that's what I presumed. Yeah. Well, that's great. Well, you know, it's interesting because, you know, you were saying that, you know, this is almost exactly the 4th year anniversary. Well, you know, it's interesting to me because that's exactly how every organization that does good work that has its 50th anniversary starts out.
Well,
You know?
I'd like to think so. Yeah, we're trying to build an organization with a lot of legs so that it exists long after the people who were at the beginning
Absolutely.
were here. So.
Well, I think it's phenomenal. It's always fascinating to me the new perspective on things that people have from time to time, and how just right on it is. You know, it's phenomenal. I think it's great. So the first few things I want to say, just to keep this whole thing brief, is to make sure that the audience who will be composed of a lot of people who have taken part in other webcasts, no question, but also who haven't, many people who haven't, or the people who have taken part are taking part again, as is often the case. People take part 1, 2, 3 times to catch all the angles on things. These slides, this one shows that if you break down the numbers in the province of Ontario, there are, last count, 13.7 million people. And the way Statistics Canada looks at the numbers, they say that if you divide that number, the total population, by 3, that this will tell you approximately how many households there are, which makes sense, you know, in the sense that mom, dad, child, or you know, any other small group configuration wouldn't be uncommon to have 3 people, 4 people in a household, however it's composed. And so that would mean 4,566,000. So if you can look at these numbers here. And if you then look at the number of people on ODSP, the provincial benefits, and they have different names in different provinces, but the amounts and qualifications and so on are relatively similar. For example, in Alberta, it's called AISH, A-I-S-H. So an acronym just like ODSP. You'll see that there are 352,000 people on ODSP between ages of 18 and 65. And that doesn't include all the children under 18, but who will one day be on ODSP, or all the seniors on ODSP who turn 65 and then receive old age security and guaranteed income supplements. But if you just take the 18 to 65, which is about 2/3 of the total number, if you were to have that total number, you'll see that if you presume that they each have one parent household, you know, they're 18 to 65, so one presumes their parents are probably alive, or good odds they're alive. And again, it's conservative. It doesn't include all the households of all the kids under 18 or over 65. Well, you can see that if you did add a relatively small number, such as 100,000 to the 352, if you were to add 1/3 of that again, you'd have a good approximation of the total number of households that have are the direct parent household of someone with special needs. So you can see that if you had 452,000 of those households, that would be 1 in 10% of 4,566,000. So it's one family in 10 that is realistically, truly, conservatively, based upon real numbers, that is a parent household of a child with special needs. And this is very interesting because that's a phenomenal demographic, phenomenal community. It's really amazing. 1 in 10. What other group do you know of that matches that? So then what you do is you look at the fact that if the child is over 18 and living at home, they're going to be getting $8.96 a month, which is the room and board amount. But in many cases, we can increase this to $11.69, which is the shelter plus supplementary. And it's very helpful to get that because it's $273 a month for the rest of their life until they're 65. And it's only the parents, the family who have those children at home who don't get that higher amount. If your child is in fully supported living and needs complete support 24/7, the organization that takes care of them will get that full amount plus core funding to provide all the other supports, because obviously $11.69 a month won't support that child. And if you look at these numbers here, it says boarders, 47,000. That's the room and board people. Those are the kids, for the most part, that turn 18. Obviously, the parents apply for ODSP for them, and they stay at home for an extended period. So it's 47,000 of 352,000, which is about 13% roughly. And they are all slotted into the 896 by default. But in a lot of cases, we've done close to 1,000 of them now, we can get this increased to 1169. So for the 15 or 20% I find of people that are taking part in this seminar, we have 94 now taking part. So my numbers are pretty close. You're going to find that 15 or 20 of those, perhaps more, are families who have a child at home who are getting a lesser amount. So this is something you should look into. If you wish to discuss it, give us a call. The next major thing is the child being approved for the disability tax credit and also making use of the caregiver credit. And if you haven't used it, then the disability tax credit turns on whether the child is markedly restricted or takes substantially longer to do things, or in some function can't complete certain functions of daily living. The test for ODSP is a lesser test. The simplest, easiest test for ODSP is that the child can't function in a competitive workplace, or can't function in the community, or can't handle their own personal care. Now, obviously, by the time you get to can't handle personal care, you're talking the disability tax credit. But can't function in the community and can't function in a competitive workplace, well, perhaps they might not qualify for the disability credit. But if they do, and if they haven't used it, which is a very common profile, we can backfile it for 10 years. And we're into the last month of this year. So this year, of course, 2019, we can backfile to 2009. And the recapture is about $1,600 a year. There's 10 years worth at 16,000 approximately. And of course, once we're into January 2020, we've lost that year. So we're in the process of hustling to get as many of these that are on the file finished, or at least filed. Because if you filed it, then in 2020, you can still usually make the adjustments. The caregiver credit applies if the child is over 18, and it's the credit of the parent, the caregiver, the sibling perhaps, that until recently with whom the child resided. Used to be that the child had to be, well, the child is over 18, has a disability, needs care, which is, these are all self-evident in the cases that we deal with. And until 2017, they had to reside with a family member who paid income tax. Now, what that means, the interesting thing for me, is that you can see here that of the 352,000, only 47 were living with someone. So only the 47,000 families, parents, could use the caregiver credit and reduce their taxes by about $1,000 a year. But now, since 2017, they've removed the reside with criteria. So I think effectively, except for a very, very small amount of of families who are, for some reason, completely estranged from their child. I would think that now 352,000 families at $1,000 a year can use this credit. So this is a big change in 2017, and it's a little known, very rarely known. And even if a person does know, they may well still understand that that the child has to reside with them, because when they looked into it, then that was the criteria. And we on a daily basis we correct this. As well, if the child is approved for the disability credit, they can have a registered disability savings plan. It's the child's property. And if you put $1,500 a year into it, if the child's 18 and older, then based upon their income, their household income, which is not your household income, it's their income from ODSP, then if you put $1,500 into this plan, the government gives them $4,500. And this happens for 20 years. If you happen to have a child who's under 18, in most cases, my standard advice is set it up, get on a list, make sure you get notices of things. But then, you might wish to contribute if you wish, but the amount of the matching grants is affected by your household income. So you may or may not get more than, for every 1,000, 1,000. So I recommend to people, set it up, get on the list, wait till the child's 18, and then make the contributions, because then you get the maximum grants and bonds. And if you do this for 20 years, you're going to get it all anyway. And the interesting thing as well is that if you do make those 1,500 for contributions for 20 years, you contribute 30 grand, government contributes 90,000, 4,500 times 20. And if it's invested at 5%, which is reasonable for those 20 years, it accumulates to a total of 200,000. And every decade thereafter, such as if you start when the child's 18, then of course at age 38, it's 200,000. At age 48, it's 300,000. At age 58, it's 400,000. And then at age 60, they can start to draw up on it, if not sooner. It's actually 20 years plus 10 years for the vesting period. Are there any questions about these things so far? Benefit increases and recapturing disability and caregiver tax credits. I'll just take a look at the questions we've received so far. When did the government contribution to RDSPs increase from 3,500 to 4,500? The 3,500 is the matching grant on the 1,500, and the other the other 1,000 of the 4,500 is the bond. So it's always been the same. How do distributions from RDSPs affect ODSP, OAS, income supplements, and CPP? They don't affect anything. One that's off from a bit of an angle here. How can ODSP recipients own their own home directly? Well, they can certainly be on title. If this is an appropriate thing, they can certainly be put on title for a home. The problem, of course, is the ODSP is not sufficient to carry it. And the contributions that the parents then make to carry the part that the child can't carry, because they get $11.69 a month from ODSP. These are deemed to be payments to the child. So you have to structure how you do this to not affect ODSP. Plus, if the house is sold, then they get the net equity proceeds, which could then, of course, disqualify them. So there are various things. So it's better to have, a serious discussion about just what it is you really want to accomplish and how to do it, rather than, take the simplistic approach. Oh, well, I'll just put it in my child's name. Are the same lines used on the tax form for disability and caregiver? No, I'll show you on the next page here. Nope. The disability tax credit for your family member is claimed on 3/18, and The caregiver credit as of 2017 is used on line 307. Let's see.
Ken, there's one that says, what percentage of an RDSP can be drawn out per year?
Well, nothing can be drawn out until 30 years have elapsed. You have to contribute for 20 years to get, or until age 49. So if your child happens to be 41, you contribute for 8 years. Then you get no more grants and bonds. You could still contribute till they're 59, but you wouldn't get any more grants and bonds. And the vesting, the 10-year vesting period, so 8 years of contributions, seesaw contributions, wait 10 years for the vesting of the grants and bonds. At that point, after those 18 years, then you could start to withdraw, and there is a formula for it. And normally it's the amount to which it has accumulated divided by 23 years. So right now you can't do anything. And as far as the grants and bonds are concerned, if you make a contribution in that 8th final year, the year in which the child turns 49, then if you say, well, okay, I'll wait 2 more years. And then when 10 years have elapsed from my first contribution, I will see if I can withdraw what I put in plus the $4,500 for year 1. Well, no, that doesn't work either, because it's last in, first out. So if you have made a contribution in the 8th year, and then you wait 2 more so that you've got your total 10 years, well, if you take out any money, you're deemed to be taking it from the 8th year, which of course is not vested. Which parent claims the disability or caregiver? Well, either one, it's the same amount, as long as that person pays income tax. And it's always been a common misconception. This isn't a reduction of taxable income so that, you know, the top taxed dollar gets reduced. It's the same tax credit for everyone, as long, you know, regardless of your tax bracket. So if you use the disability credit and you've paid income tax, then you have a tax credit, a rebate of $1,600. And it doesn't matter which parent uses it. The disability credit can't be split, but it has to be used in a certain order. If the kid pays taxes, which of course very few do, but if the child was actually paying income tax, then they have to use it first. And there's rare circumstances where that's true. Then one of the tax-paying parents or siblings, aunts or uncles, you know, some family blood relative or their spouse who pays taxes, they can use it. And then if they have maxed it out on their particular adjustments and there's something left, well, then the residue can be transferred to another person. The caregiver credit can, in fact, be split. If you wish, you can, for example, couples that are separated and have the child back and forth week after week, they could split the caregiver if they wish. And here's a very standard sort of thing. My son is now 30, has had autism his entire life. I'm just now applying for the disability credit. Will we be able to use it at this point in time? Well, if he's not approved, I presume he will be approved, but if he's not approved, then you can't use it yet. Now, if you are applying, he's 30, if you are applying to have him approved, and if the date that he became markedly restricted or that he would qualify for the disability credit is 30 years ago, and you get that date put on the T2201 and CRA approves it from that date, well, the last 10 years are claimable. And as I say, by the time you get into January 2020, it's 10 years from 2020. In December of 2019, it's 10 years from 2019. But if you apply to have it approved, and if you use it, like, well, this is I'm not giving you the best example here, but if you were to decide to go ahead and set up an RDSP and then contribute for 2019, and it's retroactively approved, well, then you would get the grants and bonds. So if you're confident that your child is going to be approved, he has 19 years left until his 49th year, so almost the full 20-year period. But if you want to make sure that you use all 19 years, then you could be bold and you could set up the RDSP in December. We're doing this on a file in Southern Ontario right now. We're setting it up in December of this year, making a $4,500 contribution to pick up 3 years worth of retroactive grants, and then getting him approved in 2020 retroactively for many years. And our experience is that if you do this in 2019 and make the actual contribution in 2019, even though the disability credit is not yet approved, but is approved retroactively, well, then you get your grants and bonds. So, be a good Christmas present. These days, getting things approved by Canada Revenue takes a long time. They're pushing back, they're asking for more information, they're sending letters to doctors to have them do again what they did before on the T2201. They're pushing back in situations where the child lives with the parents, which is like a slam dunk as far as the transferability of the credit from the child to the parent, but they're pushing back on that, you know, silliness. But what's happening, frankly, is there's more people getting approved all the time. CRA doesn't like this, and so they're trying to make it harder for people, disillusion people, dissuade them, trick them, all those things. Let's see. So just to let you know, the voluntary payment rule has changed now. It used to be $6,000 over 12 months. Now it's $10,000. So slightly over $800 a month. I'm not aware of very many families that give their children $800 a month. But this factor is useful in some cases where the parents are, for example, subsidizing rent or making other payments other than just, you know, giving the money to the child for their own discretionary use. And the asset test used to be, there was general confusion. The 6,000 was the gift test over 12 months, but the asset test was 5,000. So if you gave your child 6, that was fine. But if they kept 6, they were over the limit because they could only keep 5. Now it's 10,000 over 12 months and a $40,000 asset test. This is just information about the disability and caregiver tax credits. Everyone who is registered, not just attended, but registered, will be receiving the link, the YouTube link for this webcast, as well as the PowerPoint slide pack with all these slides.
Yeah, there's a question here.
Yeah.
If somebody's receiving ODSP and the one and only car is exempted from the asset limit of 40,000, meaning they can buy and own a car for 30.
No, the car is an exempt asset. It's 40,000 plus a car.
Okay.
Logical question here. When you start to withdraw at, well, in fact, 60 from the RDSP, would this reduce the ODSP monthly payment? No, it doesn't affect any kind of social benefits. It doesn't affect, for example, if you're receiving at age 66, which you would be, because the formula gives it the amount in the RDSP to you over a 23-year period. It does not affect guaranteed income supplements. It does not affect old age security. Obviously, this would be a serious compounding factor if you get the mentioned grants and bonds and you invested for all that time, and then when it's paid out, it offsets GIS. For every dollar you lose 50 cents. So it doesn't do that. Where can you get a 5% return? Well, it's perfectly feasible. The trick, though, is that you have to have an RDSP that is not with a bank. Because, of course, with a bank, you're going to be, at best, either given no advice and find that, this is true stuff, that 10 years later, your growth since inception, 10 years before, is 0.5%, or that in the last 6 months on $43,000, you've made $2.64. Obviously, you would be somewhat disillusioned and doubtful that you're going to make 5%. But if your money's properly invested, if you're dealing with a proper financial advisor, if the money is invested in something, with some thought given to it, even if what you do is you put it into some sort of an aggressive mutual fund, granted the MERs, the management expense ratios eat away at that, right? But it is quite possible to make 5%. You may have to do some not aggressive or foolhardy investment, but investments that don't have a lot of expenses, that keep in mind that you're going to have growth over time, that you're looking at a 30-year window in most of these cases. So it's not unrealistic. Question, can you only set up RDSPs if they're eligible for the disability credit? Yes. That doesn't mean that you couldn't set up an RDSP while applying for disability tax credits, but you can only have one, keep one, use one if you are approved for the disability tax credit. As I said, if you're in, like, for example, you're in your 49th year and you just hear about this and it's almost Christmas, you could go ahead, you could set up the RDSP, you could make a $4,500 contribution to pick up 3 years worth of grants, and you could apply to be approved for the disability credit. And if you have set it up and made the contributions in 2019, and then in 2020 be approved retroactively, you would get the grants for 2019, 2018, 2017, but not if you do it in 2020, not if you do all of it in 2020.
Ken, another one here. Does money in a TSFA affect receiving ODSP? Well,
if you have a TFSA with more than 40,000 in it, you'd be disqualified because it's an asset greater than 40,000. The present top amount for a TFSA is about 63,000. So if you happen to have a topped up TFSA, well, then you would lose ODSP. It in no way, the fact that it's somehow a tax-free savings account gives it no special meaning as far as ODSP assets are concerned. But other than that, yes, if you happen to have 35 or 40,000 and you feel you wish to set up a TFSA, well, then feel free. What happens, this is another good question. What happens if an individual with an RDSP passes away? Well, this happens. It's unfortunate. But suppose you set one of these up for your child 10 years ago, as soon as they came out, 11 years ago. In 2008, they actually started out in December 2008, but didn't really come onto the seriously onto the books until 2009. You can still make the 2008 contributions up until end of March of 2009. But suppose you've done that for the last 10 years or so, and now your child is 49, and suppose, God forbid, your child dies. Well, there would be at best 1 year of vested grants and bonds. That very first year, if all of these factors were correct and You see what I'm saying? So what would happen is the RDSP belongs to the child. It's the child's property, although the account holder can be the parents. And that'll actually lead us up to the next topic here. But the child dies, the RDSP is collapsed, and they issue a check payable to the estate of the beneficiary, the child. And the child is the only beneficiary. It's unfortunate you can't make designations of RDSPs. Perhaps one day they'll fix this, but you can't designate the way you would on a TFSA or an RRSP or, you know, those things, seg funds. But the check would be issued for the 15,000 plus growth that the parents have put in, and the 1 year vested grant and bond, I guess. And it would be payable and can only be payable to the beneficiary. So this becomes part of his estate, perhaps the largest part of his estate, obviously. And at that point, if they have a will, well, then it would go pursuant to the terms of their will. And if they don't have a will, which is, of course, most often the case, then by intestacy, there's no will. And by succession law, the surviving parents would receive it. And there's a few steps you have to take under these circumstances to actually get the money from whoever is issuing the check, and then you're depositing that into an account in the child's name. But aside from these factors, it becomes the property of the parents if the parents have survived. If the parents are deceased, then it would fall by succession law to siblings. If there was a sibling, but the sibling's deceased because they were 10 years older, for example, if the sibling has children, then it would pass to the children, and so on. There's a succession law tree of who gets what. Excuse me. Good evening, Mr. Pope. I have a Henson trust will with 2 Henson Trust trustees, so you're fortunate. My question is, what happens if my 2 trustees die before appointing a successor? Well, this could certainly happen, of course, because if the trustees happen to be your brother and sister, the aunt and uncle of your child, the odds are, of course, very good that they would predecease your child. And most of the wills and trust arrangements that I look at that are simple but correct don't have a proper trustee replacement clause in the trust section. Now, if your will does, that's great, that's excellent. And they could either replace themselves and resign while alive, or what you do is they put in their will, if I should die, special clause, if I should die the trustee of any undistributed trust, I appoint so-and-so as my successor trustee. Now, it's certainly best if they have the power to do this, if they're given the power in the trust document. Almost all of the ones that I see don't have it. But you know, you may well be able to get the bank or wherever the trust fund is being held to agree with this and honor this appointment, even if there is not such a power granted in the trust section of the will. And of course, you can test this out before you die, because what you do is you take this clause and, or you go ahead and directly and put it in your will, and then you take a notarial copy of your will, and you take it to wherever the money is, and you talk to their people, and they talk to their legal people, and you can get it in writing that they will comply with this direction and appointment, or won't. And of course, if they won't, you move the money, take it someplace where you do get cooperation and compliance. And you know, and as a part of this process, this discussion, you make it clear to whomever you're dealing with now that you're happy with their work, but we have to plan for this inevitable transition, because, you know, I'm the uncle. I'm, you know, decades older than the beneficiary child, the niece or nephew. And we have to make this arrangement. And if you can't help me, I have to know. But that's how you would do it. And you have a bit of latitude. You know, if you die, your executor has some authority, and they may well be able to simply take over as trustee if they're willing. And if they're not your age too, and they're going to die soon too. And if they wish to be the trustee, although sometimes this then requires that your will be probated to prove that it is your will, the last will, the true will, the executor is your true executor, even if your estate does not require probate. So you then wind up with a probate application to verify this trustee appointment. I mean, we've been through this stuff. So you know, I'm trying to give you a shorter answer than some of the complexities that arise. ETFs are great investments. Yes, they are. Yep, they're lower fees, and they can be excellent investments, exchange traded funds. Thanks for the suggestion. That's good comment. What benefits are available after the age of 65 when ODSP ends? Well, you apply for old age security and guaranteed income supplements, just like all other seniors. And you then get slightly more than you got on ODSP, because OAS-GIS is about 18,000 and max ODSP is about 14,000. And then of course at that time, you're not subject to any of the ODSP rules either. Now that brings us to guardianship, powers of attorney, substitute decision makers. And it's 15 to 8, so I'll try to wrap things up in about 15 or 20 minutes. At present, for an RDSP, the parents can be the account holders, but there's no one else really. I mean, it does allow the spouse of the person who is the beneficiary of the RDSP, but there's not a whole lot of people on ODSP who have spouses. But that is true, that it's the parents, and then it is also the spouse of that person. So, but to the extent that that's, you know, relative rarity, it's no one else. So that means that somebody has to be the child's legal representative. And they could, if the child is competent to sign powers of attorney, well, that makes life a little easier, because they could sign a power of attorney appointing someone together with or as an alternate to the parents to be the account holder when the parents are gone, or to help the parents. But failing that, and if the child is not competent, you may have to seek a guardianship application, a legal guardianship, which is an application to the court to be appointed the legal guardian of the child. You have to have capacity assessments, there's legal fees. It's unfortunately expensive, but there's a lot of cases where it's really the only option, and it is the best option for the transition from when the parents pass on. Who will take care of my child when I'm gone? Who's going to have legal capacity to see that he's properly cared for medically, that will protect him, to see that he's not abused, you know, or beaten up by other people in his supported living environment. And by the way, who's going to manage the RDSP payments when they commence at age 60? That's a whole discussion. This is just information about powers of attorney for personal care. That's specific to each family, actually, or each individual. Property, substitute decision makers. Just like in testacy and succession law, there is a substitute decision maker tree. And it lists the parties who are, by statute, under the Healthcare Consent Act, the substitute decision maker for the child, if they're either not competent or become incapacitated as a result of treatment. And of course, firstly, it's primarily the parents, but if it's not the parents, then it's siblings or spouses. If it's not the siblings, then it's and on and on and on. And the only problem with this is that the medical authorities, hospitals, doctors, all those, you know, they're certainly aware of the substitute decision maker legislation. The problem is that as a rule, they think they know best. Maybe they are very intelligent, very wise, very experienced, no doubt. But the way I discuss it with when I do my seminars or discuss it with my client families is, if you look at the supporting professionals, whether they be doctors or lawyers or social workers or who knows what, all the supporting professionals, if you look at them next to the family, and you put this in the context of an egg and bacon breakfast, the chicken's involved, but the pig's committed, right? All the supporting professionals, they don't have skin in the game, right? They may be well-intentioned, experienced, capable, all those good things, but they don't have the same skin in the game. And it comes right down to the family that's always there, always been there, always will be there, and also that has to take the brunt of the repercussions of whatever kind of treatment the child's given. And that's where the real decisions should come from. And my experience is that, firstly, there's a, you'll love all this, but it's all true. There's a bias against people with disabilities and also old people. And I call it the broken bicycle syndrome. You know, if you're a broken bicycle, why fix the tires? Right? Why fix the tires? So what this means, in my humble opinion, I'm very humble, perhaps the humblest person you'll ever meet, then what happens is hospitals and doctors and so on, they're trained in the triage system. And you put people into one of three buckets. One that you can certainly fix, one that you probably can fix but aren't too sure, and one you probably can't fix. And there's a bias against people with disabilities and old people, and they too often get shifted into the bucket on the one side that, you know, well, no, we can't really fix them. When in fact you could. It's just you're just not inclined to use the resources to do it. So that's my rant for the day. So in that case, if the substitute decision maker factor isn't sufficient for the proper cooperation and treatment, in your opinion, well, then that brings you back to legal guardianship, because now you've got clout. Now you stand in the shoes of that child. You know, you are that child as far as these decisions are concerned. And when we do, for example, a substitute decision maker package, it's separate from legal guardianship. We've only done it a few times, but you know, to try to get weight behind the client for a lesser cost. And we do this really nice, heavy, spiral-bound, glossy, covered package with affidavits and sections of the act and proof of birth and so on. And there's my cover letter. And of course, doctors and hospitals understand legal letterhead. And in bold words, about halfway down, it says informed consent. And to the extent that this is kind of helpful, you know, in the same way that, you know, a demand letter from a lawyer could be helpful for some circumstances, I like to think that that's about what this is good for. And if it gets you the cooperation you need, and that's all you have to do, I'm good. I'm glad. Legal guardianship is a court application. I'm just going to look at the questions and see what else we've got here. Can the parent manage a self-directed RDSP if the child does not have capacity? Yes. What are the advantages of having an RDSP over simply investing the money? Well, if you have an RDSP, if you put in $1,500, you get $3,500 more plus a $1,000 bond.
Ken, there's one question here. For kids under 18, which parent should claim the DTC, so disability tax credit, in a situation where the mom doesn't work, but the recipient is on Canada Child Tax Benefit? Should it be her or the dad who has the income?
It has to be the person who pays taxes. If the mom's at home, she doesn't have taxable income, she doesn't pay taxes. And it's curious thing, but if this, if this were a fact situation where the couple are separated, the children are with the mom, and the dad is paying child support, for some reason, the Income Tax Act provides that the child support paying parent can't use the disability credit. No idea why. When writing a will, what should parents take into account to help their son or daughter from tax problems with CRA? What should we have in place to protect our child when they inherit from us, including funds, property? Okay, well, that takes us to one of the next slides. Thank you very much. Henson Trust. So in your will, you need trust provisions to appoint a trustee or trustees, and this would name your child, or perhaps more than one child, but generally one child, as the beneficiary of this trust. So you pass on, then your wife passes on. It's always the guy that goes first, right? And no, two times out of three anyway. And so then the second parent dies, and the estate is divided three ways. And the child with Down syndrome has a Henson Trust in the will, and the executor, the other son and daughter, they settle up the estate. They get their third each, and the third for their sister with Down syndrome is transferred from the estate account into a Henson Trust account. And of course, there's a whole story there. And the thing to look at, if you have a will and you think that it has a trust, and you think that it is a Henson Trust, then the essential wording that you have to look for are absolute and unfettered discretion, which is the absolute discretion of the trustee who cannot be compelled to support the child. If they simply have discretion, they could, legally, technically, they could be compelled to support the child, which would then take them off ODSP. And ODSP knows this, so if this is the type of trust that comes to their attention, well, then they suspend benefits and oblige somebody to make the trustee support the child. But if it's a Henson Trust, it doesn't, because the trustee has absolute discretion. And of course, what this means is that they could, legally, they could withhold everything from the child. So obviously what this means is that if let's say there's two children, two brothers, and the one brother is the beneficiary of the trust and gets half the estate in the trust, and then the other brother is the trustee, this can be excellent. But of course, there's this obvious potential built-in conflict of interest, because of course, the provision in the trust, in the will, provides that when that boy dies, the beneficiary dies, what's left goes to his brother, typically. Well, if he acts with such an abundance of caution, shall we say, that it's parsimonious, is another charitable word. Well, then when that child dies, the beneficiary dies, if they've received less or less has been spent on them, well, then there's more to go to the surviving trustee as the residual beneficiary of that trust. So there's this potential conflict of interest. But everybody addresses that issue and moves forward. The size of a Henson Trust is unlimited. It can have anything in it: money, homes, properties, oil well, lease rights, anything at all. And there's no limit to what can be dispersed from it for the child's benefit. It has to be done in a certain way to minimize or negate any effects on ODSP. But essentially, the simple story here is that there's no limitation. There's no 10,000 over 12-month rule for these trusts. You see any more good questions, Karen?
Let me just see here. There's a bunch of them. This person wrote, who should you appoint as a trustee in a Henson Trust? Is it a good idea to appoint a lawyer as a trustee?
Well, normally it's family members. It's siblings, children, cousins, nieces and nephews sometimes. It's always best if you can, if you have the luxury of this, of having siblings of a similar age or cousins of a similar age to the beneficiary. But of course, lots of families don't have that luxury. So then if you don't, which as I say, that's probably what sparks this question, right? You can look at trust companies. Most of the trust companies don't want to deal with trusts of less than about 500,000. And a lot of my clients' trusts are less than 500,000. Concentra Trust will accept smaller trusts. Concentra is a good solid trust company. It's based in Saskatoon. It's owned by several very large credit unions, and their fees are less. They will accept smaller trusts. Their standard fee is 1% of the trust asset per year. So on 300,000 is 3,000, which is, I think, pretty acceptable. But if the trust happens to be 200,000 or 100,000, their minimum fee is still 3,000. So at a certain point, that becomes a bit awkward. But if it's your last and best choice, then obviously it's your last and best choice. It could certainly be a lawyer, could be some other professional. It wouldn't be your financial advisor, partly because his investment house won't let him be a trustee like this. But also, you know, they couldn't both manage the trust investment asset and be the trustee, because of course they're being compensated for the asset. And it's just seen as not sufficiently arm's length to be appropriate. And this is an awkward discussion in a lot of cases. What do we do? How do we do this? And you have to try to be creative and find alternatives. You know, sometimes there are cases where we can find ways to do without the trust, and yet also meet the client's needs as far as the planning and support for that child. So it's more a discussion process. This is just a heads up. There's a new thing called lifetime benefits trusts. And if you happen to be, or one day will be, the surviving parent, the last surviving parent, and you will have a sizable RIF, well, you know, of course, that if you pass on that it's going to fall into your estate, and you'll lose approximately half of it to the tax man. Well, a lifetime benefits trust allows you to, in fact, if the child has a cognitive disability, which is approximately a third of all the people on ODSP, you can roll the RIF over to the lifetime benefit trust on a tax deferred basis. There's more to it than this. I don't have time to go into all the details, but it is a very tax efficient method of passing on a substantial RIF for the benefit of a child with cognitive disabilities. It's held by the trustee. It's administered by the trustee. If the child dies, the trust provisions direct where what's left goes. It's very effective. Let's see what else we've got here. These are just legal wordings for qualifying disability trusts, graduated rate estates, preferred beneficiary elections. I don't think I'll go into this. This is an example of how life insurance can fund a trust, and how if you're a female 50 non-smoker, you're expected to live 35 years more. A universal life policy for 100 grand has a premium of 115 or 1,384 a year. Well, if you divide the annual premium into the 100,000, it would take you 72 years to save 100,000. And obviously you're only going to live 35 on actuarial statistics. So you'll just never save 100,000. So it can be quite a good investment. And of course, this is something people give a lot of serious thought to, especially if they expect their child to live with them until they pass on, which is, you know, a fair number actually of people. And if the child is receiving $896 or $1169 a month and contributing a big chunk of that, half of that at least, to the parent's household to help with costs, well, often you find that all of a sudden you have a few extra bucks in your pocket and you can fund the insurance to help fund the child's trust with the money that they've given you. I bought an apartment. I bought an apartment under my name, and I have a child under 40 years old who's on ODSP. I'm afraid that when I pass on, he may be tricked and lose it. Did I make a mistake? Well, it's in your name. So when you die, it could pass to a spouse, but suppose there's no spouse here. So you die, you're deemed to have disposed of it. It's a deemed disposition. So to the extent that there's been a capital gain, let's say of $100,000, 50,000 of that is taxable in your hands because you're deemed to have sold the apartment. And if you were in the top tax bracket, which most people aren't, if you were in the top tax bracket, you'd pay $25,000 of taxes. So the property's gone up by 100, 50 is taxable as income, 25 at a maximum is tax owing. So your estate pays the 25 grand. And then what you do is you have a Henson trust set up in your will, and you leave the apartment directly to the Henson trust, and the boy continues to reside in it. The trust owns it. And because the beneficiary of the trust is residing in the home owned by the trust, it qualifies as a principal residence. So it's capital gains exempt from there on, which is pretty handy. And if the child should marry, well, firstly, the title's not in their name. So they can't mortgage, they can't sell, they can't do anything. But if they should marry, it's owned by the trust. So although it's a principal residence for the beneficiary of the trust and his spouse, it's not divisible if they then divorce. And of course, in a common law situation, at least at present, I'm content they're going to change this retroactively and jerk everybody around. But at present, because that's what historically happened before. But what's going to happen is they'll change the rules retroactively with no one having any say in the matter and no way to protect themselves for common law spouses. But under the present rules, if you're not married, if you're common law, there is no division of a matrimonial home. There is no division of estates at all. There could be a claim for spousal support, perhaps, but a claim for spousal support against a person on ODSP isn't going to go very far, is it? So putting it into the Henson Trust is the right technique after you die. It's almost 10 after. Let's see what else we've got here. Nope, that's questions. So we'll look at a few questions. Karen, do you see anything else that I should respond to?
Give me a second, I'll quickly glance. Can my adult daughter, who is well, be the trustee of a Henson trust in the will if she's also a recipient in the same will?
No problem. The example of the two brothers, the one who survives and receives the residue of the Henson trust that his brother did not use, does that residue have to be included as income? This is, again, a common question. No, this is all capital. So just like any other inheritance, it's purely capital. It's just not income. So there's no tax owing. Although, of course, like any entity that dies, when the trust is dissolved, there could be some triggering of some taxes of some sort in the hands of the trust, but that's the trust problem. If the Henson Trust pays out a monthly amount to the disabled child, does that money impact the ODSP payment? Well, as I said earlier, perhaps you weren't here at the time, I see there's 96 people down from 102. So we've got still a good solid audience here. But the child can receive up to $10,000 over 12 months. So if your plan was to give the child money directly, you could give them, what is it, $833 a month, something like that. 10,000 divided by 12. That's unusual. And this is money paid out directly to the child, which again can occur. But you know, the trust doesn't normally pay sizable amounts to the ODSP recipient. It pays third parties for goods and services to be delivered to the child. And simple story, what you do is you know that you can give the child or spend for the child and report annually, because you do have to report to ODSP annually. It's not usually that burdensome. That's 10,000 over 12 months. Okay. In lots of cases, that's more than adequate. But if the plan was that it was a sizable trust and you wanted the child to live in a better style of living than that they had while you were alive, and you wanted that to carry on, which would be perfectly normal and appropriate, then what you do is you come up with a plan for the care for that child, their annual needs, their 2-year needs, their 3-year needs. And at the very least, what you do is you come up with a 12-month budget to subsidize their rent and pay for their annual vacation in Barbados, and to pay for their car lease, and to pay their insurance on their car, and to pay the insurance on the apartment, and you know, or to prepay their condo fees for 12 months. You come up with this budget based on a 12-month or 24-month or 36-month overpayment arrangement, and you disperse in a given month 10 or 20 or 30 or $40,000, whatever this plan is. And it's not, once you sit down and work it through, it's not rocket science. And if you make this very large disbursement, let's just say 30,000 in the month of January, and this covers the child's extra needs above and beyond the 10,000 over 12 months, which is still available for the next 12 months or the next 24 months. Well, when you do your annual report 12 months later to ODSP, and you say, well, in January, I dispersed 30,000 and I spent it on various things. You don't really have to, you know, justify what you spent it on, just that you did do it. You know, it's not like you have to justify what you're spending it on. You just have to say, yes, I did disperse that 30,000. You can see there's a withdrawal from the trust fund, and I spent it on all sorts of legitimate stuff. It doesn't matter. Benefit recipient was overpaid. They're $11.69 a month. And so what they do is they put an $11.69 overpayment on their monthly stub, and they reduce their benefits by $50 a month until the $11.69 is recouped. That's the worst that happens. And another thing that, you know, if this were an appropriate situation, we have one just the other day where there was a trust being set up, and the beneficiary was an adult, capable, frugal, and he was pressuring his aunt to just give him the money and forget about ODSP. Well, that's usually not the best choice. So anyway, so in the course of the discussion, the aunt did decide to proceed to set up the Henson Trust and so on, because I explained to her that this isn't the most common scenario, but in this case, we were satisfied that her nephew, her grown adult nephew, was very frugal, was unlikely to be misled or abused by people in the geared to income building that he's in. He didn't want to lose his geared to income apartment or pay market rent, which you don't have to. And you know, but he didn't want to have his aunt doling out money in little pieces. And you know, and obviously at this point in his life, he being short-sighted but very frustrated, was prepared to say, well, look, you know, Auntie, give me all the money, I'll just forget ODSP. you know, and that's usually not the best, but you know, you could do. So I said, but you know, the asset test is now $40,000. This trust is about $300,000. You could give him something slightly less than $40,000, and he could put it in his bank account and do whatever the heck he wants with it, as long as that lasts him, right? He'll have complete discretion to spend it, and it's an asset which complies with the asset test, so he won't lose ODSP. It's an asset, not income, so it doesn't affect RGI rent. How about that? And of course, this was satisfactory to this fella, because it wasn't truly that he wanted the 300,000, and it wasn't truly that he wanted to lose ODSP and his geared to income, his geared to income apartment. He just didn't want to feel in poverty for the rest of his life when there was a trust with 300 grand in it. And so that satisfied the situation. Let's see what else. We've got to call a halt to this pretty soon. How is my trustee supposed to know all of this when I'm not here? Is there a guidebook? Well, no, regrettably. But there is me. There is my office. And more to the point, what there is on your side of the picture is a letter of wishes. And we give our clients several detailed memos to help them write up a letter of wishes, which isn't binding, but gives guidance to the trustees. And it tells them all about the child, the beneficiary, and your aspirations for them, and their hopes and dreams, and the things that they love and hate. And also some of these basic rules, who are you going to call, that sort of thing. And so it's really not that complicated. Obviously you're spending all your time trying to determine just, okay, how is this all going to work, and what'll happen to my child when I'm gone. And then you've learned it all. You've watched my videos, you've taken part in webcasts, so you're pretty well versed. But then you ask me this question, well, yeah, but what about when I'm gone, right? And that's obviously a legitimate question. But the answer is, well, you write a letter of wishes about how you want this done and what you've been told will work, because I just told you. And then otherwise you say, and here's Mr. Pope's number. And either I or my successors will be here. Here's a good question. Can families use your services who live in other areas, or do you have lawyers you could recommend in the Dufferin, Caledon area? There's no doubt there's lots of good lawyers down there, but then it's a question of specialization. I can't actually direct you to somebody in that area that has experience in these matters. We serve clients all over the province, all over the country. I suggest that you fill in the family details form, family evaluation form. Contact Karen at kpopelaw.ca. She'll send you the link. We'll have an initial discussion. That's usually free. And see what needs to be done. You can talk about fees, what will this cost? And then if you decide to retain us, great. If you don't, that's fine too, of course. But what we find these days is that people find it a relief to, frankly, not have to leave their home and go downtown in Toronto or wherever it is, downtown, wherever it is, to try to find these services and to try to find them from a lawyer and an accountant and a financial advisor and a social worker. And they find the one-stop shopping from home preferable, just like Amazon. I think we're going to have to come to the end. So I am a social worker. Smiley face. That's great. That's excellent. And I can always tell the good social workers, because when I do seminars, if I do them during the day someplace and a social worker comes during the day, they're getting paid for this. And it's true, it's part of their job, or they are prepared to make it part of their job, and they're dedicated and continuing education and all these positive things. but it's still during the day, and it's only during the day, and they are getting paid for it. It's the ones that do it at night that, in my particular opinion, are the more committed ones. I think that's about it, guys. If you have other questions, you can go to the website and ask them from there, or you can email Karen at capopelaw.ca. Yeah, there we go. Karen at capopelaw.ca. And, you know, we'll do our best to reply. Karen, is there anything you want to add before we sign off?
No, just people email me their questions. I'll send them the family details and we'll get back to them that way.
Okay. Okay, well, I'd like to say thank you to everyone that took part and Merry Christmas. This is the last webcast for 2019. We'll be starting again. I don't know if we'll do one in January. I've got an on-site seminar in town here in January. But certainly in February, we'll start again about once a month, roughly. We'll have an annual update, first couple of them. They normally take a couple hours, but you're welcome to attend again. And if you belong to an organization of families or some support organization, and you'd like to collaborate on a webcast next year, just let us know. Send an email to me or to Karen, and we'll see whether we can work together. If you have a family group of some size and you'd like a personal webcast for them, we can do that too one evening. You know, a lot of people, a lot of groups have, a once a month get together. Well, let's do a webcast to the parent group that gets together in the boardroom, plus all the people that, can't attend because they have to be home with their children. And we'll see what we can do. So that said, Merry Christmas. Hope you have a good holiday, and I'll see you in the new year. Take care.